Hi there. So let's go ahead and get started because, like I said yesterday, there are some important topics to cover today, but hopefully a lot of it is a refresher from some of the important evidential principles that we covered when we did evidence law. Is remember, we tended to focus a lot on criminal evidence because that's really where a lot of the common law and the statutory principles have developed. So we're going to take a quick look at how a trial actually works in practice. We'll look at some of the pretrial issues that occur and then some of the issues that arise in terms of admissibility of various different types of evidence during the trial. So there's a couple of slides that I am not going to focus on because I think it's fairly straightforward and you just need to really read these sections yourself. So, of course, we know now that in the magistrate's court and the district court, it's a single judge, whereas in the vast majority of criminal trials, in the CFI, the jury are the fact finders. So it's up to the judge to make rulings on the admissibility of evidence, decisions on the law. He will deal with general housekeeping matters, the order of witnesses, for example. The judge also can ask questions of the witnesses to clarify any ambiguities that arise. And then at the end of the case, the judge has the responsibility for summing up all of the evidence that's been called in the case from both the prosecution's perspective as well as the defense's perspective, and then also giving directions to the jury on the law. When the judge, before the parties actually give their opening as well, the judge will give a statement to the jury in which he goes through certain basic evidential principles like the burden of proof and basically gives them a little bit of information about the different parties involved and what their role is as well. And then, of course, the judge is responsible for sentencing. Now, I was talking yesterday about taking of plea and this ability to plead guilty to a lesser alternative offense. At both common law and by statute, more serious offenses often have lesser alternatives. For example, robbery. If you look at the schedule to the theft ordinance, there are a number of lesser statutory alternative offenses stated. So, for example, lesser alternatives to robbery are theft, burglary, assault with intent to rob. So it is possible that although the prosecution have charged the defendant with a more serious charge, the defense may offer a guilty plea to a lesser alternative charge. It's completely up to the prosecution to accept that plea to the lesser charge. If they do accept it, then the judge will proceed to convict the accused on that guilty plea to the lesser alternative, and he'll then be sentenced. But if the prosecution decide to reject that plea to the lesser offense, then the trial will continue on the more serious offense, and the guilty plea to the lesser offense is considered to be a nullity. In other words, at the end of the trial, the defendant cannot be convicted just because he pleaded guilty to the lesser offense. He could be acquitted of the more serious offense and be convicted of the lesser offense because it's a lesser offense by law, but only if the prosecution have managed to establish the elements of that lesser offense at trial, not based on the defendant's guilty plea to the lesser offense, because that is a nullity. So that's the authority in Lee Y. Crim. And the defendant can offer to plead guilty to offenses that he's not even charged with, but it's up to the prosecution to consider whether to accept or reject, again, that guilty plea. And if they reject it, then the trial continues on what the defendant's actually charged with. And the judge shouldn't leave that alternative charge that the defendant is not even charged with, and it's not a lesser alternative, that should not be left to the jury. So that's the Asif Afak Mohammed case. So I've put a bit of detail for you on this next slide about what we mean by lesser alternative offenses. Defendant can never be convicted of a more serious offense than one he's charged with, but there is the possibility for him to be convicted of a less serious offense even if it's not specified in the indictment, because of Section 51, subsection 2 of the Criminal Procedure Ordinance. So on the next slide, I've just put some provisions for you here on the jury. The jury actually get to go home at nighttime during the continuation of the trial. Some trials obviously last for months. It'd be unfair to keep them sequestered, but they're given very explicit directions by the judge at the beginning of the case that they can only consider the evidence that they hear during the trial, that they shouldn't be referring or reading newspaper articles or listening to TV programs or the news about what's going on during the trial. They shouldn't be discussing the case with anyone during the trial. And then when they retire to consider their verdict, they're actually kept in the High Court building and sequestered together until they have reached a verdict. Remember that a defendant has no right to a trial by jury, right? That's been clarified as a result of the introduction of the NSL. But we may have a number of pretrial issues that are dealt with, and you may remember from evidence law, section 65B and C. So we'll do a brief refresher on that. But on the first day of the trial, assuming that all of the housekeeping matters have been dealt with in the pretrial review, then the first thing that happens is if there's an interpreter, they're sworn in, and then plea is taken again from the defendant. And it's then time for the prosecution case. In the magistrates and district court, because it's just a single judge hearing the case, there isn't actually usually a formal oral opening. In the opening address, it's the prosecution's opportunity to set out the case that is to come. In other words, what are their allegations? What is the offense? What witnesses are they going to call? What evidence will they be introducing in the trial? But the opening is a fact-based presentation, right? The opening is not time for argument or speculation. That's the role of the closing submission, in which the advocate is inviting the fact finder to draw conclusions from the evidence that has been presented during the trial, the admissible evidence. The opening, though, on the other hand, is an outline, like a bird's eye view of what's going to come in the case. So what this means is it's really important in the opening that if there is any evidence that is in dispute between the parties that has not yet been ruled admissible or inadmissible, or if any evidence has been ruled inadmissible, that the prosecutor does not refer to it in opening address to the jury. That would be very prejudicial. It would be serious misconduct on the part of the prosecutor, and the likelihood is that the trial would be immediately abandoned, the jury would be discharged, and a retrial would be ordered, because it is such a serious error to refer to prejudicial, inadmissible evidence before the jury in an opening. But what the prosecutor will do, besides referring the jury to the indictment, is to go through whether there have been any admitted facts or admitted witness statements, as well as what witnesses they're going to call and the exhibits they're going to introduce. And then they call their first witness, who is sworn in or gives the oath. And they are then ready for examination in chief. I think the duty to call a witness listed on the indictment, you can read it yourself. Basically, what happens is that on the back of the indictment, the prosecution must list all of the prosecution witnesses that they're intending to call in the case. And if a prosecution witness is listed on the indictment, the prosecutor is obliged to either call them for examination in chief or to tender them for cross-examination. That means to make them available for the defense to cross-examine them if they wish. It's only if the witness is incapable of belief that the prosecution do not have to call them. In other words, it's only if the prosecution can establish that the witness is being dishonest or lying in some way that they are not obliged to call the witness listed on the back of the indictment. Now, when a witness is testifying, all of the other witnesses in the case must stay outside of the courtroom. That is so that they are not influenced by the testimony of another witness. The only witness that can remain in the courtroom is the defendant, if he's going to testify, obviously because he's the one on trial, so he has the right to be present throughout the duration of the trial. And then it's possible that expert witnesses, but only with the permission of the court, may be allowed to sit in and listen to the testimony of the witnesses. The reason expert witnesses are given this special privilege is because in practice, they've usually produced an expert report. So there is less possibility for them to change their testimony based on what other witnesses have said. But also because as an expert witness, they are professional and their primary duty is to the court rather than to the person who's paying their fees. So they have this duty of independence and professionalism. That's why they're permitted to sit in court. Once the witness begins testifying, then they cannot discuss any of their evidence with anybody until they've concluded their testimony, not even with the counsel in the case who's asking them questions. After examination in chief, then it's time for cross-examination. And remember, in examination in chief, no leading questions. Cross-exam, you can ask leading questions. Leading questions are ones which either suggest a fact that is not yet in evidence or give the answer to the witness in the form of the question. After that, then it's possible that the prosecutor may do a re-examination of the witness. But remember, the re-examination can only arise out of topics that are covered in the cross-examination. So you can't deliberately decide not to ask a witness questions about a topic in examination in chief, hoping that you will have the opportunity to do it in re-examination. Because if defense counsel elects not to cross-examine the witness, then you're stuck. There can be no re-examination. And then once all the prosecution witnesses have testified and all of the exhibits have been produced, the prosecution provisionally closes its case. The defense have the right to make a no case to answer submission, and the prosecution can reply to that submission. The magistrate or judge then makes a ruling on whether there's a case to answer. If there's no case to answer, the defendant is acquitted, and that's the end of the trial. But if there is a case to answer, the trial proceeds, and it's now time for the defense case. Usually in the magistrate's court and district court, the defense will not give an opening. It's only really before a jury where the defense may give an opening. And it can also be a tactical decision, because in giving your opening, you're obviously tipping off the other side to your case. There's no requirement to give an opening. Remember, burden of proof. In fact, the defense may not call any evidence at all. If the defendant's not testifying, if they have no defense witnesses, then they will just proceed straight to closing submissions. But if the defendant is going to testify in his own defense, he must testify before any other defense witnesses that are going to be called. The reason's obvious, so that the defendant, getting the opportunity to sit in court and listen to the testimony of the defense witnesses, is not persuaded to change his testimony. So he goes first, and any defense witnesses have to come after him. But specimen jury directions 44 and 45, which deal with the right of silence and whether the defendant has an obligation to testify, make it clear that he doesn't. And if the defense call no evidence in the case, then it's called putting the prosecution to strict proof. In other words, forcing the prosecution to prove the elements of their offense, usually by cross-examining the prosecution witnesses or arguing in closing submission that, say, one or more of the elements are missing. So let's talk a bit about the right of silence. We covered this in evidence as well, but it's become a very important topic recently because of the CFA ruling in Chan Chu Learn. So there is a fundamental right of silence, but it's not absolute. We know under the NSL that there are certain obligations placed on suspects, defendants, to answer questions, but that's not a new concept under our statutory provisions. For serious offenses, like under the Prevention of Bribery Ordinance, failing to provide information when you're asked can also be an offense. And a defendant is always told about his right of silence when he's cautioned on arrest. So rule 2, as soon as an officer has reasonable grounds for suspecting that a person has committed an offense, he must be cautioned. In other words, you're not obliged to say anything unless you wish to do so, but what you say may be put into writing and used in evidence against you. Just give me 1 second. There's a lot of laughing outside that's quite distracting. I'm going to go and ask them to be quiet. So the candy machine seems to be broken. So there's a group of, I don't know, teenagers out there eating away, having a merry old time. I should have invited them in here. All right. Let's carry on. So what do we mean exactly by the right of silence? It protects the defendant really in 2 aspects. Firstly, I think as humans, our natural assumption is that if somebody accuses you of doing something, if you actually didn't do it, you would defend yourself, right? So first aspect of the right of silence is sometimes if somebody stays silent, it may lead to an assumption or an inference that actually they're guilty, right? Because they're not responding to a false allegation against them. But the second part of it is that if they do say something at some point, the fact that they didn't raise it initially must mean that any later explanation is not credible. Yeah. Mm-hmm. So if in the trial evidence has been produced of the defendant's flight, then as part of directing the jury, the judge would point out to the jury that flight from the scene is not evidence of guilt. But that doesn't mean necessarily that we don't have that first assumption, right? When we hear that evidence come out. And the problem is sometimes that when you make an assumption initially, it can be difficult to overturn it, right? Especially with lay people. So yes, technically, it's not evidence of guilt, but there's always a risk that it may be used inappropriately by the jury, right? So in the bail application, it's in the brief facts that he attempted to flee, right? The reason I chose to say something about it was not because I don't know that the judge or magistrate knows the law. Of course, he knows the law, right? But just really to highlight that the prosecution's case is maybe not as strong as they may be suggesting. Because remember, that was one of their grounds of objection, which is really linked to failure to answer bail. So I was trying to offer some kind of plausible explanation by saying it's just the reaction of a young man who's panicking, right? Without going too far into the defense, because I don't want to get into the cake cutter issues and the lack of CCTV and all of that. So where the defendant does exercise his right of silence, then take a look at specimen jury direction 45, right? It's not an admission of guilt and should not be used in that way. What exactly is covered by this right of silence? Defendant is protected by the right of silence, even if he or she doesn't know that they have it, as long as the defendant does not waive it. And the defendant would waive the right of silence when they answer questions, right? As soon as the defendant starts to say something in response, they've waived their right of silence. So that's Lam Si Na. Lee Fook Hing, though, which was an earlier decision, establishes as a general principle that the judge should not comment that the defendant had the opportunity to explain earlier, but he didn't, right? That would make a sort of mockery of the whole Rule 2 caution. If a defendant, having been told about his right of silence and choosing to exercises it, stays silent, and later is criticized for doing it. So that's the basis of this right of silence. Lam Sina, though, is an important case, and it gets a mention in Chan Chu Leung as well by the Court of Final Appeal. Because what Lam Sina says, yes, although this is correct as a general principle, when we are dealing with the admissibility of a confession, in other words, there's a voir dire and we're deciding whether the defendant's confession should be admissible or not, then it is permissible to cross-examine a defendant on his delay in lodging a complaint, right? Because that's just a question that is going to the admissibility of his confession. So it's this last bit that's important. Notwithstanding the right of silence, cross-examination and comment is permitted on allegations of police impropriety, like threats, beating, etc., including the delay in complaining, but only for the purpose of determining the admissibility of a confession. So Chan Chu Leung, we talked about this case in evidence law. You'll remember this is the case where the police had received a tip-off that drugs were arriving in Hong Kong. They had someone conducting surveillance at the airport so that they were able to substitute the real drugs with some fake baking powder, and they dusted it with fluorescent powder. They then watched while the defendant and someone else picked up the goods in a place in Chun Mun, put them into other cardboard boxes, and then took them to a flat in Granville Road. At which point, after they'd gone into the flat, defendant was then intercepted. So he remained silent under caution. But at trial, he chose to testify. And at trial, he really raised 2 points for the first time. First, he raised a defense of lack of knowledge of the drugs. He said he had no idea what was in the boxes. He'd just been asked by his friend R. Chu to help move the boxes from one location to another. So his defense was lack of knowledge of the drugs. But he also raised for the first time a complaint that the police had framed him. And he raised that because it was the prosecution evidence that when they were processing the defendant, and as part of that processing, remember, they take his fingerprints and his measurements, they can also take fingernail cuttings. And when they'd taken the clippings of his fingernails, they had found traces of this fluorescent powder underneath his fingernails. So that was one of the critical pieces of evidence that they were relying on to show that he had been dealing with these packages of drugs, that he wasn't just completely clueless as to what was in the boxes, right? Because they had dusted the fluorescent powder over the actual packets of drugs inside the boxes. So that was a really crucial part of evidence from the prosecution. And he alleged that the police had framed him, had planted this evidence of the fluorescent powder under his fingernails. And the reason he made that allegation at trial was because he had to really come up with some kind of explanation for how the fluorescent powder got under his fingernails if he's saying, I had no knowledge what was inside the box, right? I didn't open it. I don't know what was going on. So that's how this evidence came out. So he was convicted and he appealed to the Court of Appeal on basically two bases about his right of silence. Because at trial, he'd been cross-examined by the prosecutor about this friend R. Chu and the fact that this was the first time that he'd mentioned R. Chu. But he was also cross-examined about the fact that he hadn't made this complaint about the police framing him with a fluorescent powder to anyone at any stage up until it was first made at the trial, right? In terms of any third party, he hadn't complained to the capo or the police officers or anybody. So I've set out for you there in quite some detail. And remember, this is just a refresher, right? But basically, the Court of Appeal were of the view that the prosecutor should not have cross-examined the defendant on the failure to mention Archu earlier, because that went to his defense of lack of knowledge. So that cross-examination was impermissible. And the prosecutor had also referred to this line of cross-examination about Archu in closing submissions. So that should never have happened. But the Court of Appeal were of the view that the cross-examination on the fingerprint evidence, the fluorescent powder evidence, was permissible because it did not infringe the defendant's right of silence, because strictly speaking, it did not go to the defense. And in this case as well, they were satisfied that even if there had been an infringement, the general directions that the judge had given to the jury was sufficient to cure any prejudice. And the Court of Appeal made a lot of this phrase here. A defendant has the right to remain silent when he's questioned about the occurrence of the offense, the identity of the participants, and the roles that they played. In other words, the right of silence is restricted to the defense that the defendant raises, rather than any allegations of being framed with the fluorescent powder. So the Court of Appeal said there is no freestanding right of no complaint, which can never be asked about in cross-examination. So the case went up then to the Court of Final Appeal, but actually only on the question of the fluorescent powder. The Court of Final Appeal refused leave to appeal on the Archu cross-examination. So the Court of Final Appeal still uphold this approach in Lamsinar, that cross-examination is permissible about a delay when it comes to an issue about the admissibility of the confession. But the CFA find that this line of cross-examination about the fluorescent powder was actually closely connected to the defendant's defense because it went to his lack of knowledge. It's not an independent issue about a complaint against the police. So they say the defendant's suggestion that the fingerprint evidence was planted on him formed a central plank of his defense of lack of knowledge, and it was related to the occurrence of the offense and the role played by the defendant. So he was entitled to keep silent regarding his allegation that the evidence had been planted on him, and he was exercising his right of silence. So he should not have been cross-examined on the fluorescent powder. So far the defendant reading this judgment by the CFA is thinking, yes, score. It's looking like I'm going to get off, right? I'm going to be acquitted. But as quite often happens in these long judgments, it's like a roller coaster, right? You think you're about to win, and then you come crashing down to reality. So what they do then say is this fluorescent powder evidence cross-examination was impermissible, but in contrast to the Archu cross-examination, which was referred to by the prosecutor in closing submissions, there were no closing submissions about the recent fabrication argument. Instead, the only submissions made was that the defendant's testimony was not credible. And I think this is also crucial. At the trial, defense counsel had not objected to the cross-examination about the fluorescent powder evidence. Now, this is something that you see quite often as given as a reason for dismissing an appeal. The court on appeal will refer to the deafening silence from the bar table. What they mean by that was, if what you are now complaining about on appeal was really so bad, then you would have expected defense counsel to have objected to it at the time. But the fact that defense counsel stayed silent and did not object should be taken to show that actually there was no real prejudice caused, right? So this is a great example of why when you're conducting a trial, you have to be on your toes at all points. And you must always make sure that if there is a doubt about the admissibility of any evidence, that you object to it and that objection is recorded on the record to preserve the position for appeal. So they say, as a result, the objectionable cross-examination was relatively minor in the context of the trial as a whole. So in other words, their view was, yes, this cross-examination shouldn't have happened, but we don't think that it had a significant impact on the jury's decision, right? There wasn't an irregularity or such that affected the justice of the case. And they said that because the judge had already also given general directions on the right of silence, then that cured as well any impermissible cross-examination. So they dismissed the appeal. So conviction stood. Okay. Yes. No, it's carry on. So if the question is are you essentially asking, do you think the fact that the evidence was so overwhelming against the defendant, did that have an influence on their decision, right? We have to think back to what is the test for the Court of Final Appeal when it's granting leave to appeal, right? It's whether there's been a substantial and grave injustice that's done, right? That's one of the limbs of the test. So yes, if they are satisfied that although there were some irregularities, no injustice was actually done at the end of the day, they may dismiss the appeal. But here, I think it wasn't just the fact that the evidence was overwhelming. It was the fact that it was determined that sufficient had taken place during the trial to make sure that the defendant had not been prejudiced in his defense. And crucially here, no objection by the defense team and no reference by the prosecutor in the closing submissions. Now, it's not clear why the prosecutor didn't refer to it in the closing submissions, right? Because if there's been no objection to that cross-examination by defense counsel at the time, you would think that the prosecutor would then seize that opportunity and then refer to it in the closing submissions. So it's not clear to me whether that was just an oversight on the prosecution's case, whether the prosecutor kind of went on a frolic of his own, like a fishing expedition during the cross-examination and delved into topics that really hadn't been considered as part of the case theory. Because really, when you cross-examine on topics that go to your case theory, right? You're not supposed to go on a fishing expedition to other uncharted waters. So it's not, because you don't have the transcript, it's not clear what led the prosecutor to embark on that line of cross-examination or why they didn't refer to it during closing. It could have just been an oversight, in which case they got very lucky here. Because I actually think if the prosecutor had referred to it in the closing submissions, then the outcome of the case could have been different, because there is the risk that it may have prejudiced the jury's decision. Okay, so let's move on to the defendant in the witness box. So it's up to the defendant to decide, just like we talked about pleading guilty or not guilty yesterday. And I think some of you were surprised by the fact that I said that it's entirely up to the defendant to choose whether he pleads guilty or not, so that he may choose to plead guilty even if he has not committed this offense, right? I think as lawyers, that can be quite a hard concept for us to understand, right? Particularly as defense lawyers, like our role is to act in our client's best interests. How can it possibly be in his best interest to be convicted of an offense that he didn't do? And we don't represent whoever he's covering for, right? If that's the reason he's pleading guilty, they're not our clients, they're no concern of us. But when you take it back to the fundamental concept that our role as lawyers is to advise our client, to tell them what the law is, to explain to them the consequences, but that ultimately the decision is theirs to make, then that helps to understand the basis for that principle. So it's the same when it comes to giving evidence. It's entirely up to the defendant to decide whether to testify or not. All you can do is advise. Although remember the caveat, if you know that your client is going to get into the witness box and perjure himself, you cannot stand by and allow that to happen. You can't stop him from doing it, but what you will have to do is withdraw from representing him in the case. So I'm sure I've told you before about my favorite principle, my guiding light of being a lawyer. It's the CYA principle. Do you remember what it stands for? Did I not tell you in evidence law? I'm sure I did. CYA. Always remember that as a lawyer. Write it down. Letter C, YA. What does it stand for? Cover your ass. Always. So, as part of advising the defendant whether to plead guilty or not guilty, whether to testify or not, get everything in writing, right? The advice that you give, his agreement, always protect yourself, because it happens so often that when a defendant pleads guilty and gets a sentence he doesn't like, he comes back against the lawyer and says, well, I only pleaded guilty because my lawyer forced me to do it. Or I didn't want to testify. It's only because my lawyer told me I needed to testify that I testified, right? So always protect yourself, get everything in writing, and ideally have, well, if you're the solicitor, you don't need to, but as counsel, you always need to have this instructing solicitor present when you are having communications with the client, but always have a third party present who can vouch for the advice that you've given. But as part of advising the client, there's a number of considerations that we need to bear in mind. We need to think about whether the defendant has any previous convictions, whether if he testifies, he may have lost his protection against being cross-examined on these previous convictions. We need to think about whether it's actually necessary for him to testify in the first place. If this evidence can be more safely introduced in another way by another defense witness, there may be no need to risk it all by having our defendant go into the witness box. Because very often, defendants in the witness box don't make good witnesses. They are shaky, they are nervous, they're worried about the outcome. And if someone's nervous and sweating and their voice is quivering, they just don't seem credible. And especially if you have a client who's kept changing his story, you would be concerned about the possibility of your case collapsing under cross-examination. So defense counsel always believe quite strongly that the defense case is at its best at the close of the prosecution case, and that if the defendant goes into the witness box, it usually falls apart because they start talking about all kinds of things they never told you in conference. They contradict themselves, they're cross-examined. So, but remember, at the end of the day, it's their decision. So you'll remember section 54(1)(f), which is the shield about cross-examining a defendant on his previous convictions. Now, I just want you to make a note, remind yourselves that when it comes to any other witness in the case, they can always be cross-examined about previous convictions that they have, right? So a prosecution witness, another defense witness, they can be asked about previous convictions, provided that those previous convictions are relevant, right? Because the judge always has the discretion to exclude irrelevant, prejudicial information, right? But when it comes to the defendant, this statutory provision in section 54(1)(f) of the Criminal Procedure Ordinance applies. So it only applies to a defendant, and it only applies if he testifies. If he doesn't testify, then section 54(1)(f) in the Shield does not apply. So he could be asked questions about his previous convictions if, subsection 1, that proof is admissible evidence to show that he's guilty of the offense he's charged with, or, subsection 2, he's personally or by his advocate asked questions of the prosecution witnesses to establish his own good character, or he's testified about his good character, or the prosecutor or the prosecution witness's character has been impugned, or he's testified against a co-accused. So let's break it down a little bit more. Subsection 1, his previous conviction could be introduced if it's a precondition to satisfying the elements of this offense. So the best example is if he has a previous conviction and he was disqualified as a result, then he may be questioned about that previous conviction if he's charged with driving while disqualified, because being disqualified is an element of that offense. But it also covers more generally the common law principle of similar fact evidence. Remember, at common law, similar fact evidence may be able to be introduced. But he can also impugn the character of a prosecution witness or the prosecutor, put his own character in issue, give evidence against a co-accused. Remember, if his previous convictions do come out, bad character only goes to credibility, not to propensity. That's specimen jury direction number 38. Remember, good character is different. If he's got clear record, good character goes to both credibility, more likely to be credible, and propensity, less likely to have committed the offense. But bad character only goes to credibility. It does not make it more likely that he committed this offense. So, casting imputations on the character of a prosecution witness. It's a question of degree in the case, but certainly putting to the police officers in cross-examination that they threatened the defendant, beat him up, fabricated evidence, that would amount to impugning their character. Yeah. Where they what? Surrender their own? Where they're backed into a corner, yes. So quite often a defendant will cast wild aspersions or something like that, which is another good reason why you may not want them in the witness box, right? If your client's a bit of a loose cannon and he's made a series of allegations that are spurious, tenuous, obviously false, right? You probably would advise him not to go into the witness box unless he really needs to. But also, if the defendant does go into the witness box or calls a character witness, that's going to also cause him to lose his shield if he says he's of good character when he's got previous convictions, because this is kind of similar to the concept of rebuttal evidence, right? If the defendant says something that's not true, then the prosecution can call evidence in rebuttal to show the reverse. So we talked about this case of Chow Hon Kwon in evidence law as well, about putting your own good character in issue. When we're going through and we're refreshing these evidential principles, by the way, if I'm referring to things that kind of ring a bell in your head, but you can't quite remember what all of the issues are, right? That's a good flag for you that you need to go back and refresh your notes on evidence law, right? Because when's your exam? May. So 3 months to go, right? And you have a lot of subjects coming up. So now's the time to start going back and refreshing evidence as well. We've got our revision lectures to come, right? But my aim with the revision lectures is not that we start from scratch. And honestly, my experience of teaching this course for a while is that when there's a huge gap, like there is between the evidence law lectures and tutorials and the revision lectures, it is like starting from scratch because you've forgotten everything because 6 months have gone by. So my aim is if you can start to refresh your knowledge yourself, when we get to the revision lectures, we can really focus more on past questions, okay? So what if a defendant has spent convictions? Remember that this is where the defendant does not get sentenced to imprisonment of more than 3 months, hasn't been convicted previously. In other words, when he is convicted for the first time, he's got a clear record, and then 3 years go by, that conviction is then considered to be spent under the Rehabilitation of Offenders Ordinance. And as a general principle, is not admissible. However, there is an exception that it can be admitted in the interests of justice. Now, that exception would be rare because usually if the conviction is spent, it implies that it's minor. Therefore, it's not likely to be relevant. But where the spent conviction is for the same offense that the defendant is then charged with, or where the spent conviction is for an offense of dishonesty, so that goes to credibility, perhaps there is an argument that it is in the interest of justice for the spent conviction to be introduced if the defendant has lost his shield. And then the last exception can be where the defendant has testified against a co-accused. But remember, that means that he has to give evidence that either supports the prosecution case in a material aspect or undermines his co-accused defense. So the classic example of that is where a defendant runs a cutthroat defense. In other words, he says, he's defendant A, he says, it wasn't me, it was B. He says, it wasn't me, B, it was A. So that's the cutthroat defense situation. If defendant A gets into the witness box and says that, then he's testifying against his co-accused. And in that case, he would lose his shield under section 54(1)(f) and open himself up to the possibility of cross-examination. But before the prosecutor or counsel for the co-accused launches into any cross-examination about a previous conviction, they first have to ask the court for leave, just to make sure that the judge is satisfied that the shield really has been lost. Because if it hasn't been lost and this evidence of the previous conviction is introduced, then the prejudicial effect of it may outweigh the probative value. Then you have inadmissible evidence going before the jury, could be good grounds for an appeal. So as a matter of good practice for safety, always ask for leave. Outside of the presence of the jury, this is a matter of law for the judge to determine because it goes to the admissibility of evidence. So the way that you would deal with this in the trial is, let's say you're the prosecutor, you think the defendant has lost his shield, you want to cross-examine him on a previous conviction, right? You don't refer to it in front of the presence of the jury. You say words to the effect of, my lord, a matter of law has arisen. It may be a convenient moment for the jury to take a break, right? And then they go off thinking they're having a nice tea and some cakes, and you deal with this matter of admissibility then. Remember always, even if the shield has been lost, the judge can still prevent cross-examination on a previous conviction if the prejudicial effect would outweigh its probative value. So remember, we dealt with this tricky area of a common law exception to the introduction of previous convictions or previous bad character evidence. So it could be that the prosecutor a defendant's previous convictions in rebuttal, right? Do you remember the case of Butterwasser? That's where the defendant, say, has testified or called evidence he has no previous convictions. Butterwasser, the prosecution can seek to rebut that evidence. But there's also this issue of similar fact evidence. So similar fact evidence was a concept that we struggled with, me too, because it's not easy to understand. But it is where usually the prosecution are seeking to introduce either the defendant's previous convictions or a pattern of bad behavior on his part as probative evidence of a fact in issue in the case. So we started off with the brides in the bath case, where the husband's two wives had died under similar circumstances, and nobody had been in the room when they drowned in the bath, but he'd coincidentally taken out big life insurance policies on them and inherited a windfall when they passed away. So evidence there of the death of the first wife was allowed to be introduced in the trial for murder of the second wife to rebut his defense of coincidence, right? Because he was claiming they accidentally drowned. And then we went through these cases like Boardman and Thompson as well. Remember that the original test used to be whether there are striking similarities in the manner of the commission of the offense. But now the leading test in the UK is DPP and P. So is the similar fact evidence of sufficient probative force to justify its admission, even though it is of prejudicial nature? And striking similarities is just one of the factors that the court will consider, but it could also be introduced to rebut a defense of, say, like consent or coincidence. In Hong Kong, the leading case is Zabid Ali. So I've set out the test for you there. I think it's very similar to what is set out in your evidence notes. Sorry, I have a variety of ice packs with me today because I was already injured going into the marathon, but I'd done so much training, I was determined to complete it. So I'm now struggling with my Achilles tendon. Of course, I've made it much worse, but never mind. I got through the marathon, so it was all worth it. All right, so first limb of the test. The court has to think about what is the matter in issue to which the evidence is said to be relevant, and why is it said that this evidence is probative? If it is concluded that it's relevant to a fact in issue and it's not being introduced just for propensity reasons, then it's not just propensity evidence. So the court then considers whether the probative force is sufficiently great to make it just to admit, notwithstanding that it's prejudicial. Now, I think when we looked at some of these cases, we concluded that sometimes the court tries to wriggle out of what looks to be very much like propensity evidence in a variety of kind of farcical situations, right? Do you remember the case of the guy who's found with the powder puff in his pocket, right? And in his home, he's got photos of naked boys. And so the court concludes that the fact that he has this powder puff in his pocket must show that he's the kind of person who would commit a murder on a young boy as part of a sexual assault, right? So some of the cases are quite difficult to understand. And when we think about similar fact evidence, I think what we need to keep in mind is the court is trying to perform a balancing exercise between a situation in which a crime has been committed, but nobody's seen it, like brides in the bath, right? But the way in which it's happened is so similar that it really can't just be a coincidence, right? Common sense tells us that that can't be the case. Against general evidential principles of fairness, the burden of proof, the presumption of innocence. So that's what the court is trying to do. So I suppose really the overriding consideration is the evidence more prejudicial than probative? Because if it is, then it won't be admissible. So remember the case of R and Z? This is where the defendant was charged with rape for the fourth time. He'd been acquitted in 3 previous cases of rape. He'd run a defense of consent in each of those cases and successfully been acquitted. And so in the fourth case, I think the court finally lost its patience and said evidence of previous acquittals could unusually be included in that case to counter a defense of consent, right? Because it's unlikely for there to have been such a coincidence in the allegations that were being made against the defendant. Usually, evidence of previous acquittals cannot be introduced in a trial. It is hugely prejudicial. So there have been some cases in Hong Kong where the prosecution has actually mistakenly introduced evidence of a previous acquittal. I'm thinking of one case in particular that involved drug trafficking. And the defendant had clearly lost his shield against being cross-examined about previous convictions. And so the prosecutor had in front of her his criminal record, and she was putting to the defendant all of his previous convictions for drug-related offenses. But she mistakenly included a reference to a case in which there had been an acquittal. And so that very damaging evidence went before the jury, and it ultimately resulted in the defendant being acquitted of the charge of trafficking. So even if the evidence does meet the test of similar fact, right, if there is the risk that the prejudicial effect outweighs its probative value, it can still be introduced. And so take a look back at Specimen Jury Direction 22, which deals with similar fact evidence, right? And this isn't closed. There are obviously a number of scenarios, which is why the court has deliberately kept the test quite vague to allow that element of discretion to be exercised when it comes to the admissibility of this evidence. So we're looking for whether the circumstances of the offenses so closely resemble each other that the only reasonable conclusion is that the defendant committed them all. Did he have the opportunity to commit all of these other offenses? There is testimony from other witnesses that similar offenses were committed on other occasions. So those are all circumstances in which similar fact evidence could be introduced. So once all the evidence in the case has been called, that means that all the witnesses have testified and all of the documentary exhibits have been introduced, exhibits have been tendered and everything. It's now time for closing address. Technically, a counsel only makes submissions to a judge, right? You make a closing address to a jury as lay people. And the prosecution always goes first. Defense counsel always have the right of the last word. And in court, right, if you go into the court and you're standing at the counsel's table, you're facing the judge, magistrate, the prosecution is always on the right and the defense is always on the left, okay? Depending on how the courtroom is set up, the defense really wants to deliver its closing submission next to the jury, right? Because that's when you're going to be most persuasive and you can really speak to them. So if the jury's on the wrong side, the defense counsel will often ask the prosecutor if they can switch sides to make the closing submissions. In Hong Kong, it's not like when you see like a trial in the US and the counsel starts pacing all around the room, being very dramatic when they're making their closing submissions, right? In Hong Kong, you remain behind the bar table. You never deviate from that spot. Even you never approach the witness when you're asking them questions. If you have a document you want to pass to the witness, it gets passed to the court clerk. So you have to wake them up first sometimes. Madam Clerk, may I urge you to pass this document, or may you assist in passing this document to the witness, right? And they take it from you and they take it to the witness. You don't approach. I think also when we see these US courtroom dramas, there's always a sidebar, right? Where counsel approach the judge's bench and there's like a whispered conversation. That doesn't happen in Hong Kong. right? If you're in the magistrate's court, you have to shout from the back of the courtroom. There is no sidebar. So if something needs to be said to the judge that you don't want the jury to hear, the jury are excused. It's done out of their presence. All right, so closing address is really where you argue your case theory, right? So this is where you attempt to influence the fact finder. You draw conclusions from the evidence that's been presented. From the defense perspective, you may be poking holes in the prosecution's case, arguing that they haven't proved one of the elements, or maybe more than one of the elements, or you may also be putting forward a defense that you ran as well. And then once closing is finished, the judge sums up the case to the jury and gives directions as well to make sure that, or to cut down the possibility that there is a ground of appeal based on the judge's summing up to the jury. The judge usually prepares a draft of what he's going to say to the jury about the evidence in the case, but also crucially what directions he's going to give to the jury. So he prepares a draft of it, he gives it to both counsel, and they have the opportunity to comment on it. Of course, ultimately, it's up to the judge to decide, right? But the idea of that in practice is that it cuts down the possibility of an appeal. And the overriding requirement is that the summing up is fair and balanced. In other words, the judge should refer to the cases for both sides, the defense that's been run, all of the witnesses that are being called, and the material aspects of their evidence. And if there is an error that happens during the summing up, the prosecution is obliged to draw it to the attention of the court. Defense counsel is not, because your primary duty is to act in your client's best interests. And then we have the verdict. The jury's verdict doesn't have to always be unanimous, but in practice, they are given a reasonable length of time to come to a unanimous verdict. What's reasonable obviously depends on the circumstances of the case and will usually involve the jury coming back into the courtroom a couple of times at least, where the judge really says, are you sure that you can't reach a unanimous verdict? Why don't you go back and have another think about it? But if they really can't reach a verdict of at all, then they will have to be discharged. And if they do convict, though, then obviously it's time for sentencing. If the jury acquit, then if it's a general criminal trial, there is no ability for the prosecution to appeal the acquittal by the jury. Only in an NSL case, if a panel of 3 judges acquits, can that acquittal be appealed. So that is a good reason from the prosecution's perspective and the SJ's perspective to always apply for this certificate for trial in an NSL case by a panel of 3 judges, right? Because they want to preserve the position that if the panel of 3 judges acquits, which hasn't happened so far, but if they do, they can appeal it. Whereas if they risk it going before a general jury and the jury acquits, stuck, can't appeal it. The only possibility for them to do for following a jury acquittal is to make a reference on a point of law under Section 81D, but that doesn't overturn the acquittal. So we'll look more about that at that when we get to Lecture 6. We talked about disposal of exhibits already, so we don't need to go back over that. But once the exhibits have been dealt with, the very last thing to do is to think about the question of costs. And I think we'll do that. Can't remember if it's Lecture 5 or Lecture 6, either tomorrow or Thursday night. We'll talk more about costs. Okay, so we've made some good progress. What we're going to go on to do now is to consider certain important aspects of the trial process. We'll refresh disclosure, alibi evidence. We'll look briefly at expert evidence. Section 65B and C, we'll talk about testimony of certain categories of witnesses who are able to testify in a different way. We'll look at the admissibility of confessions, ID, and no case to answer submissions, okay? So it's 20 past 8. Let's take a break and we'll come back and we'll start with disclosure, okay? Okay, let's resume. So we're going to talk about a very important aspect of trials, criminal procedure, evidence, which is the prosecution's duty of disclosure. Remember when we looked at this with evidence, we looked at it from the civil context of discovery, as well as from the criminal aspect of disclosure. So there's a difference in terminology. But the prosecution have this very onerous duty of disclosure under the prosecution code in paragraph 12. It's a duty that begins way before the trial and continues all the way through the trial. And it's a positive duty, no duty on the defense to make their own inquiries. But of course, as a matter of good practice as defense counsel, you want to be proactive because you don't want that key piece of CCTV footage that could potentially result in your client's acquittal being deleted because the capacity of the server is limited. So always be proactive in making a discovery request to try to preserve the evidence. So as to when the prosecution should disclose material, there are requirements under the magistrate's ordinance and then the district court ordinance, but no statutory requirements in the magistrate's court. But in practice, the prosecution will or should always aim to disclose their material as soon as possible, because the risk is if they don't, then the defense will just ask for an adjournment to consider the evidence with cost consequences to the defense. So they do not have to disclose anything that is covered by public interest immunity. And this case of Nayab Ayim is in your evidence law notes, nor do they have to disclose anything that is covered by legal professional privilege. So for example, if the Department of Justice have gone and sought the views of outside counsel and counsel has written an advice, then that would not need to be disclosed. And remember, when we talk about legal professional privilege, there's two aspects of it. There's the concept of legal advice privilege, which is the communications between a client and his legal advisors for the purposes of getting legal advice. But there's also this concept of litigation privilege, which extends outside of the counsel-client relationship and covers communications with third parties, like with an expert. But remember the British Railways Board, War in the British Railways Board case, it's in your evidence notes. It's only if the dominant purpose of the communication is to seek legal advice in connection with existing or contemplated proceedings that this litigation privileges attaches. But the prosecution also don't need to disclose information which is only relevant to the defendant's credibility or that of a defense witness. So if in the course of their investigation, the prosecution have uncovered evidence to show that maybe the defendant's alibis are lying, his alibi witnesses are lying, they don't need to disclose that to the defense, nor do they need to disclose any previous convictions of defense witnesses, because the idea is the defense team can make their own inquiries, but they do have to disclose, remember, the previous convictions of the defendant. So as defense counsel, you always ask your client if they have previous convictions, and you can never, though, just rely on their answer, because they may have forgotten some previous convictions. They may think that they've been acquitted when actually they've been convicted, or vice versa. So ask them by all means at the beginning of the case, and you should, but always confirm it by asking the prosecution for a copy of their criminal record. So the onerous duty of the prosecution comes from this UK case of Keane, the broad definition of materiality. If evidence is relevant or possibly relevant, raises or possibly raises a new issue, or holds out a real prospect of providing a lead. So what that essentially means is that the prosecution should disclose information, even if it's not necessarily admissible, but it may lead the defense on a train of inquiry to other relevant admissible information. And they have to disclose information that not just undermines their own case, but may assist the case for the defense. You'll remember Li Ming-Ti, which is the leading case in Hong Kong on the duty of disclosure. This was the expert forensic accountant, Mioka Li, who I always remember as being mediocre, because that's what he was. He was the expert witness who was actually under investigation by the SFC in connection with another company of which he was a director. And the allegations against that company were very similar to the allegations against the company that was involved as the defendants in this case. And he was the prosecution's expert witness. And so the CFA go through the tests of disclosure and actually whether there was an obligation on the expert witness himself to disclose the fact that he was subject to an inquiry by the SFC. Ultimately, they conclude that that duty is on the prosecution generally, as in the Department of Justice, rather than on an expert witness himself, but that it's, and so basically the obligation is on the prosecution to ask questions of their expert witness as to whether this information needs to be disclosed. Now, in this case, the defense team made all kinds of allegations against the prosecution. They alleged that this information that the expert witness was subject to an inquiry by the SFC had been deliberately withheld by the prosecution in bad faith. They applied for a permanent stay of proceedings, and ultimately they weren't successful. The court was of the view that, yes, this information should have been disclosed. Why? Because it went to the credibility of this witness, basically, that he was called upon as an expert witness to be professional, and yet he was under investigation for not being professional as a director of another company. So that information should have been disclosed, but they were satisfied that there was no deliberate bad faith in the case, and they denied the request for a permanent stay of proceedings. So it's a very long case, but it's a case that you should at least take a look at for some of the key principles. The prosecution have to disclose unused material. That's material that they have discovered in the course of their investigation, but which they are not producing at trial, usually because it's just not helpful to their case. Sometimes because it's not relevant, but they also need to disclose inadmissible evidence as well. And if they have a prosecution witness who they've agreed to give an immunity from prosecution to, or if this witness is testifying, has already been convicted and sentenced, and his testimony may lead to a reduction in his sentence, they should also disclose that, because obviously that's very relevant for the defense, because they may want to cross-examine this witness on the question of credibility. They have a motive to fabricate their testimony. So that has to be disclosed. And then these cases here at the bottom of slide 43 are in your evidence notes as well, just going through the principles of disclosure and also the consequences of what a failure to disclose can mean, right? Besides there being an adjournment or a request for costs, if the failure to disclose is discovered post-conviction, then of course it can be good grounds for appeal and a material irregularity, which results in the defendant's acquittal. So does the prosecution have to disclose previous convictions of prosecution witnesses? The test is whether the previous convictions are likely to shake the confidence in the reliability of the witness. So in other words, it's not a must that the prosecution have to disclose every single previous conviction, right? Imagine the conviction is spent, minor, completely irrelevant. This is basically saying that the prosecution don't have to disclose it. But there are other authorities which say that really, because the prosecution have such an onerous duty of disclosure, they should err on the side of caution. And if ever in doubt about whether a previous conviction is covered by their duty to disclose, they may wish to disclose it to the judge so the judge can decide whether it's relevant to be disclosed to the defense or not. Chan Kao Tai, you'll remember this is the pop star's dad who was on trial for corruption, bribery-related offenses. he was questioned by an ICAC officer. It turned out this ICAC officer had some traffic-related convictions and had also been disciplined in the past. And the question was whether that was information that should have been disclosed to the defense. In that case, his traffic convictions, although seemingly minor and unrelated to this offense, actually turned out to have huge relevance because one of his previous convictions was for drunk driving. And it turned out that the defendant was alleging that his confession was inadmissible because this ICAC officer had, according to the defendant, had threatened him at the time. And there was evidence from the solicitor, the defense solicitor, that he'd smelled alcohol on the ICAC officer's breath. So actually, that was an example of how what may seem like an unrelated traffic conviction did actually have bearing and relevance in the case. So that's another good test, another good case to read. So I would say the two leading cases that you need to be familiar with on disclosure are Li Ming Ti and Chan Kao Tai. And also the provisions of the prosecution code, right? Paragraph 12. So the prosecution have to disclose known discreditable conduct that may reasonably affect their credibility of the witness where it's likely to be a significant issue in the case. Now, if we just look strictly at the wording of the prosecution code, it would suggest only known discreditable conduct. And actually, in effect, where a witness has been discredited. In other words, where there has been an adverse finding against them, right? Not where they were subject to an inquiry, but no bad practice or bad faith or anything was found against them, right? So they're essentially acquitted. They don't have to disclose that because it's not known discreditable conduct. And the prosecution code would also imply that if the inquiry is still ongoing, right, there's no need to disclose that either because no final result has been reached. But when we look at the case law, I think it's quite clear from the case law that actually subject still to a disciplinary inquiry, depending on what the subject nature of that disciplinary inquiry is, it may be relevant to disclose that because that's the case in Li Ming Ti. In Li Ming Ti, the expert witness hadn't been convicted of anything. He hadn't had an adverse finding made against him, but the Court of Final Appeal still held that the fact that he was just undergoing an investigation should have been disclosed. Why? Because it was relevant to his credibility. So an outstanding charge is where a witness or maybe even the defendant has been charged by the prosecution, but no final conclusion has been reached, right? It hasn't yet been acquitted or convicted. So the case is still ongoing. Should the fact that a prosecution witness has an outstanding charge against them be disclosed, right? We've got kind of counter arguments. On the one hand, we've got the presumption of innocence, right? Why should they have to disclose something that hasn't yet been proved against this witness? But then we've got this question of credibility of the witness. So the cases, I think, are quite clear that if the outstanding charge is something that goes to credibility, either because it relates to their conduct in a professional capacity, like in Li Ming Ti, or perhaps for a lay witness, it relates to their credibility in the sense of dishonesty, then that's something that should be disclosed. But if in doubt, perhaps to avoid a situation where a conviction is overturned on appeal because of a failure to disclose relevant material information, it may be safer for the prosecution to inform the defense that this witness is undergoing an inquiry or does have an outstanding charge, but they don't think it's relevant. Let's leave it for the judge to decide. The case of Brown makes it clear that the prosecution have no duty to disclose information that just goes to the credibility of defense witnesses. Like in this case, the defendant called 2 alibi witnesses, and those alibi witnesses had done what we call flip-flopped, changed their story. And so their credibility was then attacked by the prosecution in cross-examination. And that came as a surprise to the defense because they weren't aware of this flip-flopping. So on the one hand, you have the argument about the prosecution have an onerous duty of disclosure, they have the burden of proof, but on the other hand, they have no duty to conduct the case for the defense. And this is the material which, if the defense team had made proper inquiries of their own witnesses, really they could have discovered themselves. So, a couple of consequences of a failure to disclose obviously could lead to an acquittal. But if it is determined that evidence, or let's say evidence has subsequently come to light that was not introduced in the original trial, then it could always be asked that fresh evidence is introduced on appeal. There is this provision in Section 83V of the Criminal Procedure Ordinance, as well as under the Magistrates Ordinance, for fresh evidence to be introduced on an appeal. But it's quite a high threshold test, because remember, the court on appeal is not a second court of trial, right? So they don't have the opportunity of hearing the witness's testimony and being able to make those decisions about credibility. So any evidence that's fresh, that wasn't introduced in the evidence at trial, is introduced basically on the papers. So it's a high threshold test, and you basically need to have a good explanation for why this evidence wasn't available at trial, right? A good explanation would be, well, the prosecution failed to disclose it to the defense when they should have. Or it could be that a new witness has suddenly come to light that you weren't aware of before. But in very serious cases, and this is extremely rare, a failure to disclose may lead to a permanent stay of proceedings. That means that the case is basically brought to an end prematurely before the trial is concluded. This is what Nancy Kissel applied for in between her retrial and in between her original trial, after which she was acquitted by the CFA and they ordered a retrial. Before the retrial commenced, she applied for a permanent stay of proceedings. She was hoping to get the whole thing dismissed before she had to go through another retrial. But it's a very high threshold for the court to agree to a permanent stay of proceedings. So when it comes to disclosure, remember I gave you some examples in evidence law about why you always need to look at the originals. Do you remember the scarf story? The lady in Marks and Spencer's, my client, who was accused of stealing the scarf, but the security guard had seen her putting the scarf in her shopping bag. So we get all the way to trial. I look at the exhibit and it turns out it's the handmade scarf that she's knitted, right? Not actually stolen from Marks and Spencer's. There was the example of the security guard who'd seen the defendant running away from a construction site carrying 2 large bags of lead pipes. But when the counsel asked for the lead pipes to be brought into court, actually 2 officers couldn't lift up 1 bag. And yet a 60-year-old guy was able to run from a construction site carrying 2 bags of pipes. So always really important to look at the originals, not just a copy or a photo. Always important to examine the physical exhibit. Look at the back of checks to see for notations, staple marks, highlighting, pencils, etc. Always do a site visit of the scene of the crime. So, in contrast to the prosecution's duty, the defense, on the other hand, has a very limited duty of disclosure. They just have to disclose if they are running an alibi defense, if they are calling expert evidence, if they're going to make an application for a permanent stay of proceedings, or on what basis they will object to the admissibility of a confession. But they don't have to disclose their defense. In fact, in Nancy Kissel's first trial, the defense team kept her defense a secret up until the point at which she went into the witness box. They did not disclose it at any time during any pretrial reviews or anything. They don't have to disclose any statements that they've taken from any witnesses in investigating, and you should never disclose your client's proof of evidence. proof of evidence is basically a summary of what the defendant will say if he testifies in court. Why would you ever want to disclose that to the prosecution, right? That would be tipping them off about your defense. And if your client does confess his guilt to you, well, there's no need for you to disclose it. Of course, that's confidential. But what you have to make sure is you don't run an affirmative defense, because that will be positively misleading the court. And if your client confesses to you that he has committed another offense or is involved in something he shouldn't be, it's only in very limited scenarios, like where there's some kind of a danger, threat to life, that you are obliged to reveal that information. You don't have to reveal that he's committed other offenses that the police or the prosecution don't know about. Because at the end of the day, a defendant has a privilege against self-incrimination. Doesn't include an immunity from being civilly liable. He can be sued, but he has a privilege against revealing anything that's going to expose him to criminal liability. And that is the provision in Section 65A of the Evidence Ordinance. And it applies to a defendant and also to his spouse, even if the spouse is testifying for the prosecution, provided that they are compellable to give evidence, right? Remember, we had that tricky mental gymnastics issue concerning Section 57 of the Criminal Procedure Ordinance. We had to consider the competence and the compellability of various different witnesses, whether the prosecution can force witnesses to testify for them. We looked at the general position, and then we looked at some exceptions. A spouse, remember, can be compellable to give evidence for the prosecution against her husband, where the husband is charged with sexual abuse of a child of the family, right? Except if the spouse is jointly charged in the case, right? So remember, we looked at this very complicated provision, and there's exceptions upon exceptions. And I gave you that nice little summary table of competence and compellability to help you deal with some of the various different scenarios. So go back and take a look at that. But the privilege against self-incrimination does not include a situation where the defendant elects to testify in his defense. It does not include a blanket immunity. So he can be asked questions about the offense he's alleged to have committed in this case. The privilege against self-incrimination only extends to future offenses that he's not yet charged with. Alibi evidence we looked at as well in evidence law. Remember, this is evidence where the defendant says either he was not at the scene, he was somewhere else, so he has an alibi in terms of location, or he says he was with someone else at the time of the offense. If he wants to run an alibi defense, he must give advance notice to the prosecution. He must give notice at least 10 days before the start of the trial, and he has to comply with the requirements in Section 65D. So he has to give reasonable particulars of the alibi. The reason is the prosecution have the burden to disprove the alibi. So they need to be able to go and investigate it before the trial begins. If the defendant doesn't comply with this alibi requirement, then two consequences inevitably arise. One, the judge may refuse permission for this alibi evidence to be introduced at the trial. That's probably rare in practice because the judge would be concerned about refusing a good defense from being introduced and therefore it being grounds of appeal and the conviction being overturned. So the second consequence is more common. That is that late introduction of the alibi evidence or failing to comply with the requirements, the judge may still allow it to be introduced, but it goes to the weight to be attached to that evidence. Of course, there can be other consequences too, like adjournment and costs as well. But if the defendant is running an alibi defense, remember, the judge has to give a lies direction. So we've got these leading cases, Yun Kwai Choi, Mo Xiu Xing, right? If it is the case that there is a real risk that the jury will use the defendant's lie as evidence of guilt, then the judge should give a lies direction. But just the mere assertion that the defendant's not telling the truth doesn't necessarily mean that a lies direction has to be given. It depends on whether there's a risk that it could be used in an improper way, either to support the prosecution's case or as evidence of guilt. So lies only go to credibility, not to guilt. And in order for the lie to be used to strengthen the case, it has to be deliberate, has to relate to a material issue in the case. There's no innocent explanation for it, and it's either admitted or proved by independent evidence. Remember, a person can lie for many different reasons. Embarrassment, to protect someone else, nervousness, they just say the first thing that comes into their head, or perhaps like my children, maybe they're just pathological liars. So it doesn't always mean that a person is guilty just because they're lying. Expert evidence, I think you can largely read through this provision yourself. This is another situation in which the defense do have to give advance notification to the prosecution as soon as practicable. In practice, these are questions that are asked in the pretrial review questionnaire or the case management conference questionnaire, whether any expert evidence is going to be disclosed. So that's something that has to be disclosed in advance by both sides, not just by the defense. And consequence of not complying, it may not be admissible at trial. Section 65B, hopefully you remember, this is Section 65B and C are effectively time management devices. These are where both sides agree that certain evidence can be introduced to save time and costs in the trial. So the aim of it is to narrow the issues in dispute. So Section 65B relates to the formal admission of written statements. And when we considered evidence, we looked at certain statutory exceptions to the hearsay rule. We looked at Section 22 and Section 22A. But Section 65B of the CPO is not a statutory exception to the hearsay rule. Basically, if this written statement of a witness is allowed to be introduced under 65B, it has the same weight as if this witness had orally testified to the contents of that statement in court. So it cannot include any hearsay material. If there's hearsay material in the statement, either it needs to be redacted, or if redacting it means that the statement doesn't make sense, then you have to come up with a new statement, or you can't admit it, right? But you cannot have hearsay material in a statement that's being admitted under Section 65B because it's not a statutory exception to the hearsay rule. And there's certain formalities that need to be complied with. Like, for example, the written statement has to have a declaration of truth at the end of it, has to be signed by the maker of it. And it has to be served on the other side, and they have 14 days to object. Remember, if they don't object, then the statement is admitted into evidence. So when you get this request made, you need to consider carefully what your case theory is. Because if you would want to cross-examine this witness, then in practice, you should never agree to admit this statement. Because usually, if the statement is admitted, it means the witness is not coming to court to testify. So you will lose that right to cross-examination. The only exception is in section 65B4, if you can persuade the court to give leave for this witness to be called. But then leave is not guaranteed, right? You need to have a good argument why this witness should be called to testify. If the statement is admitted, you can call evidence to contradict, but it would sort of make nonsense of the whole procedure, right? If you agree to admit a statement where you disagree with the contents and you're going to call other evidence to contradict it, why would you ever agree to admit it in the first place, right? So the best course of action is, if you don't agree with the contents of the statement, if it's contrary to the case theory, then just object within the 14 days and it doesn't get admitted, and require that witness to come along and testify so you can cross-examine them. 65C is the formal admission of facts. So you have, usually the prosecution will draw up a draft admitted fact, send it to the defense team for them to agree. It's a joint document though. So even if it's originated by the prosecution, the defense can add things in, delete things. Both counsel end up signing the admitted facts. But if the fact is admitted, it is conclusive evidence. You cannot contradict an admitted fact. And the judge or magistrate cannot reach a verdict that is inconsistent with an admitted fact and cannot sentence contrary to an admitted fact. So be very sure before you agree to admit a fact. And as defense counsel, if your client has a clear record, you absolutely want that put in the admitted facts. Why? Because we know good character goes to credibility and to propensity. And remember, I said about an hour ago that at the very start of the trial, one of the first things that's dealt with is whether there's any admitted facts in the case. So if it's put in the admitted fact that the defendant has a clear record, it's introduced at a very early stage of the case. And there's lots of authority to say if defense counsel does not put the defendant's clear record in the admitted facts, that is severe incompetence, flagrant incompetence by defense counsel, and good grounds of appeal. So the admission stays with you on an appeal and a retrial, very difficult to undo. You need leave and a very good explanation. I forgot, I got it wrong is not going to be a good enough explanation to withdraw an admitted fact on appeal. So just a few practical tips here. I think you can read these through yourself, but the only one I really want to highlight for you is this one, right? Remember I said that you always want to check the criminal record with the prosecution. What if the prosecution come back to you and they say either the defendant has a clear record or he has one conviction for theft and the defendant tells you he has two, right? Does that mean it can be put in the admitted facts, right? Can you as defense counsel sign off on an admitted fact which says that the defendant has a clear record because the prosecution say that he does, but your client has told you he does not? So the courts have been very clear. In that situation, defense counsel is under a duty not to sign the admitted facts because they've been told something to the contrary by their client and they would be positively misleading the court. As defense counsel, this puts you in a very tricky position here because you have to remove this reference to the clear fact from the admitted fact, right? And then, of course, what does the prosecutor think? Why would they not want that to go before the court? Oh, maybe I haven't checked the criminal record. Maybe the version I have isn't up to date. So I'm going to go back and do a new search. Oh, look, there he does have a criminal conviction, right? So the ultimate result may not be in the defendant's interest, but you have preserved your reputation and your ethical duties. And you'd have to run this all through your client and inform them that you are bound ethically to do this. But CYA, remember, anything that you agree to admit, you must get your client's consent to it. Have them sign a copy of the admitted facts. Always be very careful what you admit because it's very difficult to undo later. But the purpose of admitting is to save time and costs. And the consequences of not admitting something which you should have done and you don't challenge at trial could be cost consequences against you for wasting the court's time. Okay, we're making our way through vulnerable witnesses. Remember, these are special procedures that are in place to protect a certain category of witness who are felt to be more susceptible, perhaps, to being influenced or may break down under pressure. So there are basically 4 types of vulnerable witness: children, mentally incapacitated people, witnesses in fear, and complainants in specified sexual offenses. The prosecution usually requests these procedures to be put in place. Defendant can object, but the whole purpose behind these provisions is to protect these category of witnesses. So unless the defendant is arguing that perhaps proper procedures haven't been complied with, so they haven't complied with the statutory requirements, in which case that could usually be easily fixed, or they're arguing that there's some great prejudicial effect that's going to attach to these procedures being used, usually the prosecution are permitted to use these vulnerable witness provisions. So you can look through the statutory definitions to see how the various different categories of vulnerable witnesses are defined. Just bear in mind that a defendant does not qualify as a child under these provisions. So if the defendant is of young age, they are not permitted to give their evidence by way of these procedures. Okay. On the other hand, if they're mentally incapacitated, the defendant may be able to use that himself. Yeah. Is an emancipated child. I'm not sure what age you can apply for emancipation in Hong Kong, but if their age is within the definition, then yes, I would have thought they would still be. But I'm sure you have to be 16 at least, right, to be emancipated in Hong Kong. I don't actually know. I'm sure my oldest daughter would love to apply for that if she could. I don't think she'd meet any tests, though. She can barely dress herself. All right, who's a witness in fear? 79B. We have these 2 leading cases, Wong Kwai Nam and Siwa Lun. Remember that Siwa Lun took the definition of a witness in fear much further to just a fear of meeting the witness face to face. We also have a complainant of a specified sexual offense, basically the victim of a rape, indecent assault, or something like that. They can give evidence using these procedures. Remember, these procedures can be combined, right? So you may have a witness testifying by live TV link as well for possibly cross-examination, having first had their video recording introduced as evidence in chief. But not all provisions apply to all types of vulnerable witness. So, for instance, a witness in fear or a complainant of a specified sexual offense, the only possibility for them to give evidence is by the live TV link. They cannot rely on video recorded evidence or deposition. 79B, the live TV link, this is where they do their evidence in chief and their cross-examination from a separate room in the court building. So they're physically separated, but everybody can see and hear, and the rest of the trial is exactly the same. They get asked all the same questions in examination in chief and cross-examination. On the other hand, a video recording under 79C, this is where a pre-recording of an interview between either a police officer or a social worker or a clinical psychologist employed by the government and the child or the mentally incapacitated person. So a pre-recorded video is allowed to stand as the evidence in chief. And the court should give leave for this to be introduced unless the requirements of the section are not complied with. So let's say, for example, the child witness has subsequently died after the video recording has been made, right? That would be one situation in which the court would not give leave for that video recording to be introduced. Why? Because the witness is not available for cross-examination. So you would have a very prejudicial slant to the case because you have evidence going in, and in the video recording as evidence in chief that's not capable of being tested in cross-examination. So if this video recording does go in, then the child would still have to come to court and testify, which is why you combine it with the live TV link provision for the cross-examination. But challenges in the cases that have been made to these video recorded interviews have been along the lines of, well, the police officer was asking very leading questions, just putting words into the witness's mouth. So the prejudicial effect of the video recording outweighs its probative value. Or another objection that's been made is that the person conducting the interview wasn't a social worker or psychologist employed by the government, right? It's an outside private practitioner. So the requirements of the section were not met. So those are the types of challenges that tend to be made. Whether they are successful or not depends on the situation. And then the last is the deposition option. This is rarely used actually in practice in Hong Kong. This is basically where the witness is in really severely bad health, and there is a concern that the witness will not survive through to the trial. So a deposition is taken from them at their hospital bed. And they can be still cross-examined literally at the hospital bed by the other side. 79F, I think you can read yourself. This is just a way of sidestepping the defendant from electing a preliminary inquiry as part of the committal process. This is where you want the prosecution wants a speedy committal up to the CFI because they have vulnerable witnesses involved, and they don't want to delay the trial by the committal process, which can take a while. But they have to act quickly, and they have to serve this notice of transfer before the defendant elects a preliminary inquiry. And then a more recent provision is 79I. This was used a lot during COVID, remember, where witnesses are unable to travel to Hong Kong to testify live in the courtroom. So they are permitted to give evidence outside of Hong Kong under Section 79I. But it doesn't apply to the defendant. So the defendant can't go off on holiday and ask if he can testify from his vacation home. It doesn't apply if the evidence can be more conveniently given in Hong Kong. So even post-COVID, it's still being used where, for example, an expert witness has a conflict in their diary that perhaps conflicts with the trial. They could be permitted to give that evidence from overseas, but not where it's not in the interests of justice. Usually it would be all right with an expert witness because of their duty to the court and their independence. Okay, let me just take a sip of my drink. Let's have a quick look on the chat. I can see there were some questions. Okay, one question. If the evidence is still disputed at the opening, when will the evidence be determined on whether it's admissible? In an ideal scenario, these issues about the admissibility of evidence have been all dealt with pre-trial, right? It would have been perhaps raised at the pre-trial review by one side or the other that they were concerned about the admissibility of a particular piece of evidence, right? Like if there's a challenge to the admissibility of the confession, that's something that's obvious from an earlier stage. But if it hasn't been resolved by the time the trial is ready to start, then it would be dealt with as a preliminary housekeeping matter usually. But sometimes during the trial, an issue about the admissibility of an evidence arises for the first time, right? In which case you may need a voir dire during the trial sometimes to determine the admissibility of evidence. So it really depends. The difference between brief facts and admitted facts is huge. Brief facts, remember, are drafted by the police at an initial stage of the case. They are just the prosecution or the police's allegations, right? If it is a magistracy case and the defendant pleads guilty, they form the basis on which he is sentenced, because as part of his plea of guilt, he is asked whether he agrees the brief facts. And if he agrees them, he's then convicted on the basis of his guilty plea and his admission of the brief facts. So they can provide information for the magistrate on which to sentence. So very differently from brief facts, which are initially just allegations, unless they are agreed by the defendant as part of his plea of guilty, admitted facts are prepared for a trial, right? Only in the situation where the defendant has pleaded not guilty and there will be a trial, these are prepared usually by the prosecution as a draft, but agreed to by the defense to narrow the issues in dispute at the trial. Usually, the prosecution will generate the admitted facts, the police will generate the brief facts, but of course then they become part of the case if it goes to trial, because if it goes to trial, the prosecutor and the magistrate will usually use the brief facts in substitution for an oral opening. Is there any difference between the document's charge sheet and action? An allegation is usually prepared if the brief facts are not ready at the early appearance in court. So if the police haven't had time to draft up the full brief facts, the prosecution may just hand up an allegation to the magistrate. The charge sheet, though, is different. An allegation is kind of like a precursor to the brief facts, right? It's more brief in nature. The charge sheet would detail the actual charges, right? And the provisions of the statute. So what he's actually been charged with. Okay. So let's move on to the admissibility of a confession. And I'll get out ice pack number 3. All right, so hugely important topic, frequently comes up in the exam. When we talk about a confession, we're talking about an admission of guilt. An admission is much wider in scope. An admission can be just to a fact, right? We have admitted facts. So a confession is a narrower form of admission that relates to guilt. That's the difference between them. Remember that a confession is technically hearsay because it's an out-of-court statement that is being introduced to prove the truth of the matter asserted. If the defendant says, I committed the murder, that's his confession, and the prosecution seek to introduce that confession, what is the purpose for which they are introducing it? To prove the truth of the matter asserted, that he is the murderer, right? So it's technically hearsay. But confessions against interest fall within an exception to the rule against hearsay. So they are admissible as an exception. With a confession, we need to firstly think, is it admissible? And secondly, if it is admissible, what weight do we attach to it? So the question of admissibility is for the judge to decide. It's a question of law. Only if he decides that the confession is admissible should it go before the jury, because the jury are the fact finders, and it's for them to determine the weight of admissible evidence. But if the confession is inadmissible, then it shouldn't be referred to in front of the jury, except if the defendant himself, for tactical reasons, chooses to refer to the involuntary or inadmissible confession. Okay, we'll talk about that in a minute. But as a general evidential principle, remember that any piece of evidence, in order to be admitted, has to be relevant. So if the confession is not relevant, because it's not a confession to this crime that he's charged with, it's a confession to another crime, then it shouldn't be admitted because it's irrelevant. Most of the cases you read talk about confessions to a person in authority. And we'll look at what that means. We'll refresh our memories. But technically, you can confess to anyone, right? You can confess to the person sitting next to you, your buddy, that you've done something. It's just that the case law focuses on persons in authority because they have more scope to influence and exert a confession against a defendant's free will. So fundamental principle E, if it's to a person in authority, the confession has to be voluntary, not obtained by threats, promises, oppression, or fraudulent misrepresentation. Remember, if you're answering a question about confessions in the exam, set out the law, the test, burden of proof on the prosecution to prove the voluntariness of the confession beyond reasonable doubt. If it's involuntary, it's inadmissible. But even if it's admissible, the judge still has a residual discretion to exclude it if various different scenarios arise. Remember, we looked at this case of Lam Chi Ming. This is the murder case in which the police did a reconstruction. The defendant's record of interview at the police station had been ruled inadmissible because he was beaten up by the police. But they'd also done a video reconstruction. They'd taken him up to a cliff top and he'd pointed out where he had thrown the knife that was used to stab the murder victim into the sea. They sent down the divers, retrieved the knife, and it was held in that case that actually the video recording of this reconstruction was also inadmissible because it was tainted by the record of interview that was threatened. And even gestures and demonstrations can amount to a confession. But the Privy Council go on to say, if when the murder weapon is recovered, if there's some derivative evidence on it that can link to the defendant, that can be introduced. It's just in this case, it's really obiter because there was no derivative evidence because there were no fingerprints on the murder weapon because the sea had washed them away. But this case is still held to be good authority for this derivative evidence. The way that I think about it is the fingerprints on the murder weapon were one step far enough removed from the impropriety for it to be able to be fair to admit this evidence. Remember, we can have various different types of confession that are made. Silence, whether silence can amount to a confession or not, no, because the defendant has the right of silence. But when we come to think about the various different types of confessions and the police impropriety, remember the timing is key. Because in order for the police misconduct to have affected the admissibility of a confession, it has to be either before the confession or at the time the confession is made. If the conduct happens subsequently, if the defendant makes an oral confession at the scene and nothing untoward has happened, but 2 hours later back at the police station, he's beaten up by the officer, you can't rely on that subsequent beating to allege that the original confession at the scene is inadmissible because what happened, what went wrong is later in time. Remember, we have different types of confession. So inculpatory, an admission of guilt, exculpatory, a denial, or sometimes a reason, a plausible explanation. A mixed statement is where there are both incriminating and excriminating parts. And leader fan, the whole of the statement is admissible into evidence, but the judge may tell the jury the incriminating parts are more likely to be true. The exculpatory parts have less weight. In other words, the whole statement goes in, but the different parts of it carry different weight. Technically, a partial confession can be admissible according to this case. It's very old though. And I would think that these days it would be quite rare for a partial confession to be admitted because if it's taking place at the police station, it's usually either audio recorded or video recorded. So you don't usually get partial confessions at the police station these days. And in order for a partial confession to be admissible in any event, what is said, firstly, has to make sense, and secondly, must really be, in fact, a full confession, right? If what the defendant has said is vague, capable of multiple interpretations, like, sir, give me a chance, right? That's actually been held in Hong Kong. That does not amount to a confession. The police always write it in as like the opening part of a record of interview. Sir, give me a chance. But actually, what does that mean, right? It can just mean, stop hassling me, let me go, I want to get home for dinner. It could mean I committed this offense, right? But it's not actually a confession of guilt. So to determine the admissibility of a confession, in practice, remember, we have these two alternatives. We have a voir dire, which is a separate trial within a trial on the admissibility of evidence, or we have this option of the alternative procedure. So under what scenarios do we need to have a voir dire, right? If there's no issue of police misconduct, defendant says he confessed, don't need a voir dire. If he says he confessed, but he says only did so because I was beaten up, definitely need a voir dire. If he denies he confessed, actually, we still do need a voir dire, even if he doesn't allege any beatings, inducement, etc. Because if the defendant says, I did not confess, and the police said, yes, you did, then the logical conclusion of that must be, if the defendant's telling the truth, they have fabricated this confession. So that's why you need a voir dire, right? So that the judge can consider whether it's fair to introduce this confession or not. But remember the double-barreled situation. This is where the defendant says, I didn't confess, but he also alleges at the time the police say he did confess, they beat him or induced him. That's the Thongjai scenario and the double-barreled allegation. And you do need a voir dire in that situation because a denial plus an allegation of misconduct are not mutually exclusive. So there's our summary chart. Principles, never forget the principle of relevancy. Voluntariness, leading cases, Ibrahim, DPP, and Ping Ling. Principle E. Remember Chow Ching K, it's an objective and a subjective test. Any conduct on the part of the person in authority that's capable of amounting to an inducement or a threat or oppression. If so, have they proved beyond reasonable doubt that the inducement did not influence the mind of the accused? In other words, the prosecution have to show that what happened did not cause the defendant to confess, right? That's the subjective part. If he would have confessed anyway, then the inducement has not influenced the mind of the defendant. Residual discretion, right? This is where the judge has found the confession to be voluntary, but he then considers whether to exclude it on some other evidential ground. For example, its use would be unfair at trial, or it was obtained in an unfair manner, or its prejudicial effect outweighs its probative value, or there have been substantial breaches of the rules and directions. So let's turn to each of these in particular. You'll remember Dio Kinanen, the classic test of the person in authority, someone who has authority or control over the defendant personally or over the criminal proceedings or the investigation. So a police officer, an ICAC officer, the judge, they are all people in authority. An employer has authority or control over the defendant, right, as to whether they keep their job. But a private security guard, let's say the security officer at the airport, when you put your stuff on the X-ray machine and you go through that, they are not people in authority. But it's also relevant to consider whether the defendant perceives this person to be a person in authority. So they actually have to be a person in authority, and the defendant has to perceive them to be a person in authority. So we had these two cases, Nguai Man and Lam Tat Ming, remember, where the police officers or the ICAC officers were undercover, right? In Nguai Man, they were disguised as fellow prisoners planted in the cell. They were just passively listening in on a conversation. So in that situation, the defendant did not perceive them to be people in authority. He actually thought they were fellow prisoners. And they played just a passive role. They did nothing to encourage the defendant to confess. They were just listening in. In Lam Tat Ming, this was undercover ICAC officers that had mounted a sting operation. And they had an informant who basically arranged the meeting. They had a wire in his ear and they were feeding him questions to ask. So they played an active role in conducting this investigation. But nevertheless, the defendant did not perceive them to be people in authority, right? Because he didn't know what was going on. They were undercover. So the question of voluntariness there doesn't arise because there isn't this question of person in authority. But actually what happens in that case is the court considered its residual discretion to exclude the confession, because it was unfair in the circumstances for him to basically be entrapped into confessing by the active role that the officers took. So we talked in our evidence lectures about examples of violence, threats will suffice, beatings, being hit over the head with a copy of the old address book, right? The yellow pages, the white pages, because it doesn't leave a mark. Dunking heads down toilet bowls, that kind of thing, the waterboarding. Yes. The butler? I've never heard of an ICAC butler. Mm-hmm. Okay, so the question is, if the ICAC arrive at your home and let's say your helper, I think that's probably more common in Hong Kong than a butler, right? Your helper opens the door and the ICAC officers say, oh, we're here to arrest the person inside, but we're going to give you half an hour to think about it. And then later they take them to the station and then they detain them for the whole day. Actually, that's a legitimate tactic of the ICAC officers, provided that they comply with like the rules and directions, right? So they can detain them for up to, well, in excess of 78 hours sometimes, right? Depending on the circumstances, especially if it's a national security case. But in theory, 48 hours at a bare minimum, right? As long as they're giving reasonable comfort and refreshment, meals, water, etc., right? They have no obligation to speedily question them. So yeah, that's a legitimate tactic. When I do the tour of the ICAC headquarters with my PCLL students, right, they take us around the whole North Point facility, and the ICAC officers are very, keen to kind of show you the cells and basically to talk about how these abuses don't really happen anymore. Because in the old days, there was always lots of allegations about things like the aircon being controlled. So it was like unbearably cold or unbearably hot. And that was used as a method of oppression. Or perhaps that, the loud music was played into the cells. So there was no opportunity to sleep, or constantly banging on the metal doors and stuff like that. So now it's all like centrally controlled, like the individual ICAC officers have no ability to influence or change the climate in the rooms, right? The lights go on and off at, fixed times and everything is monitored and video recorded. So there are less scope for abuse these days. Okay, other examples of involuntariness, inducements. Remember, this is where an offer of an advantage is made. So we have the question of what if it is self-generated or initiated by the defendant? We had Chan Yip Can, in which the defendant made the offer to the police officers of assistance. The officer said, well, I'll consider it, took him before a more senior officer, and the court said, in that case, it was an implied inducement. Even though the defendant was the first one to raise it, it had effectively been adopted by the police officer. And so the police officer had taken on the self-generated inducement of the defendant. But on the other hand, in Chao Ching K, when the defendant made an offer, if you release my girlfriend, I will cooperate and I will tell you about 2 other burglaries I did, the police officer gave no response. And so there was nothing to indicate that the police had accepted this offer that was generated by the defendant. So that did not amount to an inducement that rendered the confession inadmissible. So the conclusion is an inducement can be originated by the defendant. It can start with the defendant's offer. Whether it will render his confession inadmissible depends on whether it's adopted by the police, whether they give an indication that they're accepting it or not. If they just stay silent, then they haven't adopted it. Fraudulent misrepresentation is basically where the defendant thinks that he's signing, let's say, just a witness statement. He doesn't realize that he's signing a confession. In that case, a JODA that renders his confession inadmissible. And oppression, this is where we generally talk about a climate of oppression, where a series of events have occurred such that the defendant's free will has been sapped. So when he confesses, it wasn't his true confession. So we have to look at things like, how long did the questioning last by the officers, right? In your example, yes, they can detain him for as long as they want. Well, in compliance with the 48-hour, 78-hour rule, whatever, 72-hour rule. But if, say, for example, they question him for 12 hours without a break, that would be unreasonable in the circumstances. So that could amount to a climate of oppression. We may also look at things like, was he unnecessarily handcuffed at the scene? We may look at the individual characteristics of the defendant, right? You remember from tort, right? The eggshell skull principle. That applies here too, to the oppression. If the defendant's character is such that he is particularly vulnerable to abuse, then it's more likely that a climate of oppression has subsisted or been created. So we may look at his age, his health characteristics. Residual discretion in the context of a confession is like stage 2. If the confession is ruled to be voluntary and inadmissible, there is still the possibility for it to be excluded in the exercise of the judge's residual discretion. But it's rare for it to be exercised in the context of a voluntary confession. Because if the confession has already been found to be voluntary, then the court will say, well, if the conduct complained about was really that bad, it should have rendered the confession inadmissible. So therefore, it's rare to exercise the residual discretion. Where residual discretion tends to succeed is if there is no issue of person and authority or voluntariness, right? If we're just looking at some other reason for excluding the confession, like in Lam Tap Ming, there isn't that issue of voluntariness or person and authority there because the defendant didn't realize that there was this informant who was undercover and the ICAC officers had the wiretap, right? So he didn't perceive them to be people in authority. So that's a situation in which the residual discretion may be exercised. Another example is where the rules and directions don't apply. Remember, the rules and directions only apply to law enforcement officers. So if the confession is given to someone who's not a law enforcement officer, the rules and directions don't apply, we might be looking to exercise the residual discretion maybe for unfairness, right? if you trick your friend into confessing, right, you're not a person in authority. It, strictly speaking, doesn't come within the definition of voluntariness. So maybe it's a case for residual discretion. So unfairness, remember Chan Kao Tai, an expanded definition, not just whether it's unfair to use it at trial, but could cover the way in which the confession is obtained. Prejudicial effect outweighs probative value. That's just a general evidential principle. And when it comes to breaches of the rules and directions, usually we need either a very large number of breaches or more than one breach, right? A cumulative breaching of minor provisions, or we need a very serious directional rule that's breached, like showing the accused a confession of the co-accused and inviting reply or comment. Hey, here's the confession of B. He says it was all your idea. You better confess now. You'll get a more lenient sentence. Something like that would be a breach of Rule 6. So that would be a very serious breach. That would be a good example of a situation in which there would be a substantial breach of the rules and directions. The Mushtaq direction is the unusual scenario I alluded to earlier, where I said that if the confession is ruled inadmissible, it should not be referred to in front of the jury, right? Because the jury should only hear admissible evidence, right? So if the confession has been ruled inadmissible, it doesn't get referred to. But the defendant can introduce it himself, of course, right? In addition, if the defendant's confession has been ruled admissible and the defendant chooses to give evidence, he may continue to allege that he confessed, but only because he was beaten, induced, or threatened. So this is what the Mushtaq direction covers. It covers a scenario where the jury hear about the threats, beatings, etc., which the judge has already ruled were not sufficient or didn't believe the defendant, and therefore the confession is admissible. It's a direction to the jury that if they do think that this confession was only obtained because of threats, inducement, etc., they should disregard it. So that's Specimen Jury Direction 113. So there's a question in previous lecture, you mentioned there's no fruit of the poison tree principle in Hong Kong law. How does that relate to Lam Chi Ming case then? As that case also said that evidence from tainted confessions should be inadmissible. The way I view the fruit of the poison tree and the Lam Chi Ming case is that in Hong Kong, there is no overriding principle that any time there is an unlawful arrest or an unlawful search, anything that follows must be inadmissible, right? There's that concept in other jurisdictions, but not here. So what that means from our perspective is that the admissibility of each piece of evidence has to be separately considered. It's not caught by some large fishing net that something went wrong originally. So the Lam Chi Ming case is, yes, the record of interview at the station was inadmissible because he was beaten. Now we have to think about the admissibility of this video recorded reconstruction, right? Is that admissible? Well, no, because it happened shortly after the tainted record of interview was done by the same officers who did the tainted record of interview, and the defendant was still operating under the effect of that beating that he obtained, that he was subjected to at the time of the record of interview. So that went out as well, right? But then we think about the knife, and in the sea, if it had fingerprints on it, the prosecution could have introduced that fingerprint evidence as proof independently, so the Privy Council say, to show that the defendant's fingerprints were found on the murder weapon. And they could have introduced that evidence without having to talk about how they obtained this evidence. They could introduce the evidence that fingerprints were found on the murder weapon and they belonged to the defendant without having to introduce the tainted evidence of how they found it. So that's where Lam Chi Ming says that this derivative evidence is admissible, because it's one step far enough away from the tainted confession. Hopefully that answers. It's not an easy case to understand. And at the end of the day, it is still obiter, because in the actual case, there were no fingerprints on the murder weapon. So just a reminder here on this slide that you can confess to anyone. It doesn't have to be a person in authority. The same principles still apply, but for your purposes, the exam questions always relate to people in authority, right? I'm not going to try and send you down the rabbit hole of a confession to someone who's not a person in authority, if that was a question that arose in your exam, okay? Never forget the issue of causation. Causation is always really important when we're considering the admissibility of a confession, because the misconduct, the threat, the inducement, etc., has to have caused the defendant to confess. And if too much time has passed between the misconduct and the confession, if the misconduct is after the confession, if the confession is given to someone completely different from the person who beat up the defendant, then the chain of causation may be broken. So always look at the timing, because remember, getting rid of one piece of evidence, right, or one confession doesn't necessarily result in an acquittal. There may be other confessions that still go into evidence. And remember also, a confession is said to be the best evidence against a defendant. So if all the police prosecution have is the defendant's confession, right, there's no other evidence against him, that is sufficient to convict, as long as the confession is admissible. So how does the confession get challenged? Remember the two different alternatives: voir dire, possible in all three courts, but generally only in the CFI. The alternative procedure, when you deal with the admissibility of the evidence in the course of the trial. Usually the voir dire would take place before the jury is impaneled in the CFI, because it takes time and you don't want them waiting around. Usually it's done outside of the jury's presence, because it's a question of law for the judge to decide. Very rarely, and I have never seen it done in practice, the defendant may ask for it to be done in the jury's presence. Usually the only example I could think of is where, for tactical reasons, the defendant may want the jury to hear about these threats, beatings, etc., trying to curry some favor with them, maybe. But that's very rare. Usually it's done outside of the jury's presence. So I summarized for you the procedure. I think you can read these slides through yourself. Generally, the judge doesn't give reasons for ruling the confession to be admissible or not. It's only if there have been a number of allegations about threats, inducement, etc., and he's nevertheless decided the confession is admissible, that generally he would explain why for appeal. The alternative procedure saves time and cost, because you don't have the evidence being repeated. So I've summarized all the steps for you here. If the defense is challenging the admissibility of the confession, they have to draft this formal grounds of objection. So you can read the next few slides through yourself. Let's turn to ID evidence. Let me see. Yeah, we're gonna plow on. So, identification evidence. Remember that just like any other piece of evidence, there's two parts to it. Firstly, is it admissible? Secondly, if it is admissible, what's the weight that we attach to it? So generally, whenever students see something about identification in a fact pattern, they think, oh, Turnbull, right? There's a question of identification, must be Turnbull. But remember, Turnbull only applies where the ID evidence is admissible, because Turnbull is a direction to the jury, or that the magistrate reminds himself about, as to the weight of admissible ID evidence. So if the ID evidence is inadmissible, we don't need to consider Turnbull. okay? But Turnbull talks about the judge directing the jury about the circumstances of the identification, the length of time, the distance, the lighting, whether the person seen was known to the witness. And where the defense are alleging a case of mistaken identification, then the jury need to be warned about the special need for caution. So the general dangers of ID evidence, even an honest witness can be mistaken. Look closely at the circumstances of the ID, the specific weaknesses in the ID evidence. Did this witness have eyesight problems and wasn't wearing their glasses, right? Specific weaknesses. Was the lighting poor, etc.? Must summarize the strengths and weaknesses of the ID evidence. So if there is good ID evidence because the suspect has been ID'd in an ID parade, right? That's something that the judge should point out to the jury under the Turnbull guidelines. When do you not need a Turnbull direction? Where the ID evidence is inadmissible, where the defense is not mistaken ID, right? If we go back to the test in Turnbull, where the case against the defendant depends wholly or substantially on the identification, which the defendant alleges to be mistaken, right? So if the defendant accepts, yes, I was at the scene, I was identified, I punched the victim, but I did so because I was acting in self-defense. This isn't a Turnbull case, right? Because there's no issue of identification. If there's no ID evidence, you don't need Turnbull. If all that the witness can say is, I saw a man wearing a black coat running from the building, you don't need Turnbull. That's just a general description. So I put for some points about ID parade. You don't always need an ID parade. If the witness knows the defendant, you don't need an ID parade. My mother doesn't have to come and identify me in an ID parade. If there's no issue about identification, you don't need an ID parade. In fact, the ICAC officers told me actually during COVID, there were hardly any ID parades. Why? Because everybody on the streets of Hong Kong was wearing surgical masks. So how can you have an identification parade under those circumstances when all you can see is a person's eyes? So they rarely had to resort to ID parades during COVID. Other forms of identification, remember we can have group ID, confrontation ID, we may have photo ID, but we may need to think about the prejudicial effect of all of these pieces of identification. If a witness is just shown one photo and that photo is of the defendant, that's very prejudicial, right? Usually the witness should be shown a variety of photos or a photo book and asked to look through and see if they can see the person that they saw committing the offense. I put for you some other more recent cases about looking at someone's social media site in order to make an identification as well. And then other forms of identification like voice identification. This can be admissible. This is a legitimate form of identification, provided you have a useful sample. The sample is long enough and there's no huge distortion for an accurate identification to be made. We've also got the possibility of identification by handwriting, right? As long as the sample is proved to be a genuine sample, you can have even a lay witness identify a piece of handwriting as belonging to the defendant. So your mother could testify that that piece of handwriting is your handwriting because they've seen your handwriting on a number of occasions. Usually, though, expert evidence would be called where there's a dispute about handwriting. And you can also have fingerprint evidence, of course, or you can have a lack of fingerprint evidence. In that case of Huang Ji Huan, there's a drug trafficking case. And the defendant's defense was, he's not a drug trafficker. He's a drug addict. He was at that particular place to take drugs. He wasn't involved in the trafficking operation. And so the lack of fingerprints on the drug packaging was used by the defense to show that he wasn't involved in the drug trafficking. So lack of fingerprints on crucial equipment or exhibits can also be relied on. And remember the most prejudicial form of identification, the doc ID, right? Doc ID, though, again, students tend to think, oh my goodness, there was a doc ID, must be inadmissible, right? Sometimes it's permitted, but it should not be permitted if it's the first time the witness is being asked to identify the defendant because of the hugely prejudicial effect. So if identity is in dispute, if no prior form of identification was attempted, no ID parade, no confrontation ID, then a doc ID is hugely prejudicial. On the other hand, a doc ID is permissible if the witness and the defendant are known to each other. Like I said, my mother doesn't have to pick me out of an ID parade, but she could be asked in court for the first time whether the person sitting in the dock is her daughter, because she knows me. There's no issue of identification. Or the police officer who arrested the defendant can in the dock say, yes, that's the person I arrested. We don't need an ID parade first. Sometimes if the defendant has refused to participate in an ID parade, that could be used to justify why the prosecution want to do a doc ID. But usually, because of the prejudicial effect, they should have attempted some other form of identification first. So we've got the leading case, here, Huang Duhua, and also the Queen and Christie. And remember this case about Osborne and Virtue. This is basically where the witness testifying did identify in an ID parade, but just can't remember the details. The officer may be allowed to testify about the fact that the witness picked out the person in position 5, and that person was the defendant. But in practice, before any witness testifies in court, it's good practice as counsel to tell them to refresh their memory by reading through the contents of their witness statement before they testify. So that would avoid them forgetting the details, right? Because any witness who gives a statement to the police gets a copy of it, right? So they should always read that through before they testify in court. Last topic that I really want to cover today is no case to answer submissions. Unlike the Super Bowl halftime show, right? This is usually called a halfway submission. It shouldn't really be called a halftime submission. This is the test that has to be applied at the close of the prosecution case, whether the jury properly directed may convict rather than will or must. That's the Galbraith test. And this is a very low threshold for the prosecution to satisfy. It's way lower than beyond reasonable doubt. So where there is some evidence, but it's inherently weak or inconsistent, where the prosecution's evidence taken at its highest is such that a jury properly directed could not convict, then the judge should stop the case. But where the strength and weakness depends on the view to be taken of the witness's credibility, and there is evidence on which the jury could convict, then the case should go forward. So if the evidence is inherently weak, inconsistent, contradictory, if that evidence taken at its highest is such that a jury properly directed could not convict, then the judge should stop the case. That's the second limb of Galbraith. So a very low threshold. And the prosecution can reply to the no case to answer submission. If the defense is successful, then the defendant is acquitted. If there is a case to answer, the case goes on, and it's time for the defense case. So the threshold of prima facie case Galbraith, very low, just some evidence on all of the elements. Tactically, because it's such a low threshold to get over at the no case to answer stage, defense counsel may sometimes choose not to make a no case to answer submission, because they will feel that if they do make the submission and it's inevitably rejected because the threshold is so low, they will just end up repeating the same arguments in closing submission. And therefore they'll have less effect because the judge has already heard them when the test is much higher. So they may just choose to save those arguments for closing submission, knowing that inevitably there is going to be a case to answer. Now, in the old days, when things were much more fun in court, you used to get some kind of indication from the magistrate sometimes. So he would say, like, for instance, Miss Norton, is there any no case to answer submission? And if you said no, say, really? I'm going to stand this case down 10 minutes. Go and think about it. And then you come back and you go away and you think, oh my gosh, what have I missed? Oh, I better make a no case to answer submission. Oh, wait, he's acquitted. Great. That's the end of it, right? Or sometimes you'd make a no case to answer submission and the magistrate would say, I find that there is a bare case to answer, like bare, like we just got over the threshold. And then you would know, you'd say to your client, don't testify. Like, that's my advice. The judge has given his, magistrate's given an indication that the prosecution case is very weak. My advice is they're not going to satisfy the test of beyond reasonable doubt. So I advise we call no evidence. We proceed straight to closing submissions, and then lo and behold, the defendant gets acquitted. So bare case to answer. But now they don't do that because they would be criticized on appeal. So it's not so much fun. Stay of proceedings. I think I will leave you to read these through yourself. Very rare to succeed in practice. This is where the burden is on the defendant to show that there should be a stay of proceedings permanently on the balance of probabilities. And the leading cases are Li Ming Ti, but I've also put Ng Chung To Raymond and Nancy Kissel as well as the practice direction. Remember, this is one of the rare scenarios in which the defense do have to disclose in advance if they are planning to make an application for a permanent stay of proceedings. But in the vast majority of cases, they are not successful because the threshold is so high. Nancy Kissel tried it and failed. She argued that her case was so notorious that no jury in Hong Kong would possibly not have heard about it and have been influenced by all of the prejudicial pretrial publicity. So she argued that a fair trial was impossible. That failed. She argued that the prosecutor in the original trial had committed such serious errors of misconduct in introducing hearsay evidence and inappropriate cross-examination that a fair trial was not possible, denied. She argued that her health had declined so much in her time in jail that she couldn't adequately represent herself in her defense, declined. So very rare to get a permanent stay of proceedings. In the Ng Chung To case, actually, this was really serious misconduct on the part of the ICAC officers in deliberately coaching prosecution witnesses. And even despite that, still didn't get a permanent stay of proceedings because the court's doing a balancing exercise and the charges, murder, and in this case, corruption, such serious offenses, it's hard for the court to say that it's just for these proceedings to be permanently ended. Okay, so any questions before we disappear? Are these procedure-related things examinable? You do know that this is a case on criminal procedure, right? So yes, the answer is, revealed by the title of the course, anything relating to procedure is examinable. Anything in your notes, lecture materials, tutorials, content of lectures, etc., is examinable. Exception, the national security law. I will not draft exam questions on the national security law. I don't want to get in trouble. But also, no, seriously, there hasn't been enough case law really. So I really want you to know about it because it's so important. But I won't test you on it. Okay? That's the only thing I'm taking off the table. Everything else is on the table. Okay? So see you tomorrow. Big lecture on sentencing. Okay? Really important.